beyond legal representations, Tamimi is actively involved in the ecosystem of Qatar and actively participating in various programs. I had a chance to work with to speak with Tamimi team recently and learned about their other events that not just working with their clients, governments, and semi-governmental companies, but as well being part of schools and universities. However, I must highlight that their biggest achievement, I think, so far is being the program partner of the DHL4SMEs. So thank you for that. I would like to welcome Matthew from Tamimi to say a few words, and then we will continue.
Thank you, Yulia. Pleasure to meet you all. Tamimi, I don't have to add anything about Tamimi after Yulia's introduction, but we're very proud partners of this programme. It's grown beyond our wildest expectations, so I hope my colleagues who are subject matter experts in these topics will provide a fascinating seminar for you tonight. And I enjoy the evening, and we look forward to working with all of you. And thank you.
Thank you, Matthew. So let us start. Our first speaker is Ms. Katrina Wilson. Ms. Katrina has been in Qatar for 23 years, all this time working on the legal side of Qatar. Ms. Katrina is a trusted authority on employment law and workforce strategies. She's advising private, government, and semi-government entities, offering insights into Qatar nationalization policies and labor compliances.
Thanks very much, Julia. Very nice to see you all. Before we start, I thought it would be good to get an idea of the audience. So it would be helpful to know of the people, the companies in the audience, which are licensed by the QFC, if any. Okay, so we've got a few QFC. QFZA? Yeah, a few. Okay. QSTP? Okay, not many. Okay. And the rest, obviously, the ministry. Okay, so we've got some from both onshore, so to speak, and the free zones. That's good to know. And of the sort of number of employees that you have in your companies, are there many of you that have, say, less than 10 employees? No, mostly bigger. Oh, there are, okay. And over 50? And this isn't because I know figures that the ministry are about to come out with, it's just to get an idea myself. Okay, that's good to know. Okay, so what I thought we'd do first is speak about the sort of the rationale for nationalisation in the GCC. Because as you'll be aware, it's not just Qatar in the GCC that has introduced nationalisation legislation. We have seen that through all the countries in the GCC. And the reason for it is that over the last 50 years, we have seen an influx of, let's call them expat workers into the GCC countries. So the countries are needing to adopt workforce nationalisation strategies to deal with not only the national workforce, but also the expatriate workforce. As you'll probably be aware, in Qatar, Qatarization is one of the focuses of the Qatar National Vision 2030. And the aim is to ensure, amongst other things, that Qatari citizens are represented and working not only in the public sector, but also in the private sector. And I think one of the things to think about is that the focus is not to replace foreign employees per se. The focus of nationalisation laws is to ensure that the national population have as many opportunities to work within and be part of private sector companies, and also part of the training that's often offered in those companies. Thank you. So a little bit about the history of nationalisation in Qatar. And as Julia mentioned, that actually goes back quite far in Qatar. Obviously, there has been a push for nationalisation in the oil and gas sector for years, and everybody has been aware of that who's lived here for any length of time. The more interesting thing, perhaps, for a number of people is actually that the 1962 labour law, which is the law that was in force when I first arrived here, actually had provisions in respect of nationalisation. And the priority in employment and also the priority in respect of not being made redundant was given to Qatari nationals and then other Arab nationals. So Qatar has got a long history of actually having legislation in place. And in 1997, there was a cabinet decision which set the level of quota in the banking sector in Qatar at 20%. So then we had the 2004 labour law, and in the 2004 labour law, again, well, actually, there are more provisions in respect of Qatarisation, and that relates to everything from recruitment through to training, and we'll come on to that in one of the later slides. Apart from the banking sector, under the labour law, generally a lot of those provisions weren't applied on a day-to-day basis. But again, in the next slide, we'll talk about that and look at how it's important to look at those provisions at the moment, especially while we're waiting for the regulations to come out under the nationalisation law. So as I mentioned, the Qatar National Vision sets out requirements in respect of the workforce, and one of the requirements of it is to have a future-ready workforce. Part of that is ensuring that Qatari nationals are integrated into the private sector and are developing their work skills as part of the private sector. So last year, the nationalisation in the private sector law was passed, and it aims to give priority in employment and training to Qatari nationals. And that also applies to children of Qatari mothers. So when I talk about Qatari nationals, I'm talking about nationals as they're legally referred to, and children of Qatari mothers. So the law came into force in April 2025. It relates to hiring, training, and qualifying. And as some of you may have followed in the press, at the end of last year, the Ministry of Labour set out certain focus business sectors for nationalisation. Now, those are actually the focus business sectors under the third part of the 2030 plan. So those are listed there, and I'm sure that most of you will have read about those and in the press, and some of you will be from those sectors, some of you won't be. There are requirements to register details. There have been various platforms that have been referred to, and also there is talk of benefits and incentives and penalties that will apply, and we'll come on to those in the next slides. So, what are the key developments that we've got now that we've got a nationalisation law? What is clear from the law itself is that it applies to private enterprises, so that's sole establishments. It applies to commercial companies, so companies that are registered, that have a commercial registration. It applies to private institutions for public benefit and sports organisations. The minister has been given the ability to add other companies to exemptions, but some of the exemptions that we have already been mentioned in the law are Qatar Energy companies and joint venture companies of Qatar Energy. So effectively, that is a replication of the exclusions from the labour law. So I know one of the questions that has come up from various people in energy is how far that exclusion extends. What I would say is if you are not, as a company, excluded from the labour law, then you will not, under that exclusion, be excluded from the nationalisation law. Since the law came into force, and actually prior to, since it was published in October, various platforms have been established. Tautin, Kawada, Astama, and Basha, and those, the roles of those are various, from actually inputting your employee data to portals for nationals looking for employment, through to Basha, which is where you actually register the e-contracts for Qatari national employees. So if we look at the obligations, there's obligations to notify of vacancies within 1 month. And also another key obligation that there is under the law is the biannual reporting of the workforce composition. So in that, you will have various details about the functions of the employee, their salaries, the country of birth, in order for the Ministry of Labour to be able to have sight of that. As mentioned, we are waiting for further details. So we're expecting resolutions any day. In the last week, there's a rumour that I've heard that it will be next month, but I don't know. And what I will do in the next slide is actually give you some ideas about what you should be doing now and where you can look to for guidance now, even whilst we're waiting for those regulations to come in. Other thing is the fact that these enhanced platforms, in order for there to be transparency as to who you're recruiting, who you're needing to recruit, and who you have recruited. The key there is to ensure that as a company, you are regularly auditing and ensuring compliance with these requirements under the law on a continuing basis, actually. As mentioned, we will be getting regulations. Those regulations will provide us with more detail on certain matters. And the key matters I know that everybody's very keen to know is things like quotas and things like if there's going to be any certain job roles that will be the sole preserve of nationals. I can't predict that at the moment. What I can do, though, is let you know what you do need already to be complying with. Because when a company hears that, oh, we're waiting for various regulations, it's very easy to think, oh, well, there's nothing to do at the moment. There is quite a lot to do, because as we'll see here, not only are some of these requirements in the nationalisation law itself, and often they're quite clearly set out in the nationalisation law, some of them, and they don't require any more regulations, but also they're set out in the labour law, albeit, as I said before, that those provisions were largely not particularly adhered to prior to the nationalisation law coming into force. So as of now, you as companies need to keep in your mind that priority in employment needs to go to Qatari nationals and the children of Qatari mothers. And as part of that, the Ministry of Labour will act almost like a recruitment consultancy. So you will feed into, and you should already have been feeding into the Ministry of Labour your requirements for new recruits that you're looking for. in order to make sure that you comply with those provisions. Later on, we will talk about penalties, but penalties for not complying with these provisions, which are clear at the moment, are under the nationalisation law, it's 10,000 rials for each offence. Under the labour law, the penalties are between 2,000 and 5,000 rials. And that, depending on what we're talking about, that would be a per employee penalty. So as I mentioned, there's a requirement for companies to inform the Ministry of Labour regarding job opportunities. Then, after the recruiting, there is an obligation to inform the Ministry of Labour within 60 days of hiring. And there are also the biannual reporting requirements. Again, each of those requirements are clearly set out in the nationalisation law. So companies need to be complying with those. And even when you have a moment, or if you think, oh, well, perhaps, you know, they haven't mentioned my sector as a priority for nationalisation law, those are requirements under the labour law as well. So the safer course of action for companies is to comply with those requirements. The labour law actually set out training of Qatari national requirements. That is something that we are waiting for more information to be provided under the regulations. The other thing, actually I haven't got the bullet point here, but that is clear, is that when you employ a Qatari national, there is a requirement to upload the specific national employment contract onto the Bashar portal. So it is already there if you go onto the Ministry of Labour website. And what I will say is, at the end, my details are, so if there's any of these portals or anything that you are having difficulty finding, then get in touch with me and I can send the details to you. The other thing that's very important is a provision in the labour law which, and my litigation colleagues are very aware of it when advising companies in the past, especially on dismissals and penalties that are levied against employees, is the requirement that there has been for over 20 years, if you have 10 or more employees, to have your staff regulations, staff handbook, and also your penalties, disciplinary policy, approved by the Ministry of Labour. Now, there's a provision in the labour law regarding that. It has to be said, probably most companies did not historically do that, even though that could jeopardise them if they were trying to enforce some of those, if it came to litigation stages. The ministry itself actually, when it had workshops at the end of last year, and also in a circular that I know it has sent out to some companies, has informed companies of their obligations to comply with this. Now, there are standard forms, sort of templates, under two different ministerial decisions in 2005. But this is something that we have found, because we've been helping clients actually register their handbooks and their staff regulations, let's call it, and penalties policy. As a company, you would probably want to make certain changes to that template. But it is something that you definitely need to get on with getting to the Ministry of Labour very soon. And I think the reason that the ministry has clamped down on this is in preparation for more Qatari nationals coming into the private sector, and therefore, you know, wanting to ensure that certain things that companies just actually ignored for many years, generally speaking, now to make sure that they comply with those. Could we have the next one? Okay. So I won't spend very long on this slide. Penalties under the nationalisation law. I know that lots of people have been very concerned because they hear a figure of 1 million. The 1 million figure is in respect of fraudulent behaviour as regards the nationalisation law. And I think what that probably anticipates is once we know what financial incentives there might be, if parties are fraudulently trying to get those incentives. But as I said in the previous slide, when it comes to telling the Ministry of Labour that you have vacancies, when it comes to informing the Ministry of Labour after you've actually recruited, when it comes to informing them biannually of all your employees, and also making sure that your Qatari nationals' employment contracts are on Basha, then that has, if you're not doing that, then the penalty starts at 10,000 riyals. Initially, though, there will be a grace period and companies will be told that they need to rectify their wrongdoings. After that, there could be suspension of transactions, so a block on work visas. But if you get to the fine stage, that's what you're looking at. And also, as I mentioned earlier, the labour law penalties are between 2,000 and 5,000 riyals. So it's key to, ensure that you're maintaining compliance and that you're accurately reporting. Perfect. So what I thought we'd have a little look at is how other GCC countries have dealt with nationalisation. Now, there's no use thinking the GCC is one homogenous group when it comes to nationalisation. It absolutely is not. But at the time when we are waiting for regulations regarding things like quotas or roles that will be the sole preserve of nationals or financial incentives, I thought that you might find it useful to have a little bit of a whiz through some of the other countries and see what's required elsewhere. Now, what we find elsewhere in the GCC, as regards quotas, everything between the requirement to have one national only, and that's actually a requirement that has come in recently in Oman for 100% foreign-owned companies. So those could be very small companies, but there is a need to have one national. Generally speaking, the isation requirements go up to 10%. Having said which, for example, in Oman, you will find in banking it's 60%. But again, it's not one homogenous group of countries. Oman has a much higher Omani population as regards the number of expats. Also, again, 60% in banking. Qatar, which has only recently introduced nationalisation law, has had a requirement to have 20% national workforce in banking for, my maths is no good, but a long time, since 1997. So that maybe gives a little bit of an idea as to what we might expect on quotas. Another thing that the nationalisation law contemplates is that certain roles may be the sole preserve of nationals. So if we look to Saudi, for example, there are certain job functions which are can only be filled by nationals. Again, that might be something that we have. What we have had in the last 6 months is the classification that came out from the Ministry of Labour of all the job titles. So I think that perhaps gives an indication that that is something that they might be looking to. The other key question, and that's why I was asking the size of companies in the room, is, well, maybe my company is too small and we won't have to comply, or will the requirements be different depending on the size of company? So what we can see by looking throughout the GCC is that, for example, in KSA, generally speaking, nationalisation requirements don't apply to companies with less than 10 employees. Having said which, there are certain, for example, ICT sector where it's 5. But again, please don't sit there and think, oh, well, we've got less than 10 or we've got less than 5. The requirements under the labour law do not give any minimum number of employees. So if there is a requirement that is in the labour law that you're not yet complying with, or in the nationalisation law that is clear and obviously doesn't need further regulations, then you would be advised not to sit and think, well, we don't have enough employees perhaps to need to worry about that and comply with it. Financial incentives. In the nationalisation law, you'll have seen that it hints at the fact that there will be financial incentives. So if we look elsewhere in the Gulf, we see things like salary sport, we see pension contributions being paid for the first 5 years, things like child allowances being paid. So perhaps, again, I can't predict what the regulations are going to say, but those may be the kinds of things. The social allowance payment may be one of those, which ranges between 2,500 and 6,000 odd, depending on the employee. Those may be the financial incentives that we see in the regulations. The other thing that the nationalisation law hints at is other incentives. So again, if we look at another country in the GCC, there are concepts of good and bad employers as to whether they do or don't actually comply with the requirements. And in Saudi, what they do is give visa privileges for employers that meet certain criteria. And on the flip side, there are restrictions on those who are seen as bad Saudization employers. This is one I picked up in Saudi. A good Saudization employer also allows a company to have priority when it comes to government contracts. The other thing that, if we look elsewhere in the region, is that free zones are exempt. Now, I know that's one of the questions that people are very keen to know the answer to in Qatar, is the nationalisation law going to apply to the QFC licensed entities? Also, is it going to apply to the QFZA and QSTP? We don't know at the moment. But if we look elsewhere in the region, then those types of zones are exempt. It doesn't mean that that's what's going to happen here, but it's just as it is in some of the other countries. Okay, mindful of time. So action steps. I suppose the key ones really, don't ignore the law. And this isn't just looking at the nationalisation law, as I said, this is looking at the existing provisions in the labour law and making sure, you know, if before you walked in here today you weren't fully complying, to ensure that you bring your practices and policies into place to ensure that you are complying going forward. Make sure that there's systems in place whereby the reporting goes swiftly to the Ministry of Labour after recruitment, and also the biannual reporting. Obviously, making sure that the e-contract is registered. And I think probably the other important one there that we haven't covered in earlier slides is staying up to date with announcements, staying up to date. We are expecting regulations or decisions to come in very soon. And I imagine that, the key issues that everybody's looking at or looking for the answers to is quotas, is to do with roles specific, is to do with financial incentives or other incentives, and just keep an eye out on those. And also, as I mentioned when I was talking about the portals, my email and QR code is up on the next slide. Maybe we could put that on. Yeah. That we send out client alerts. So if you want to be on the list for that, then get in touch and we can put you on that. Otherwise, what I look to, the Instagram page of the Ministry of Labour is a very good starting point to hear things as soon as it's happening. At the moment, when there's workshops that they're calling people to, obviously you need to look at more than Instagram for your answers to these questions. But if not that I'm a spokesperson for the Ministry of Labour, but you will find usually that that's one of the first alerts that something's happening is on their Instagram page. So I would say that it is worth following as well.
That's a wealth of information. I think, Katrina, we have some questions for you in the crowd. Yeah? Sorry?
Hi, my name is Mohsen. We have a QFCA entity called Himaya. We are in the insurtech space for blue-collar workers. So the question relates to two things. One is that impact of this nationalization programs. How would this impact the blue-collar workforce arriving to work in construction and in other areas? The second piece is that you asked about the good, bad employers, right, from a nationalization. So is there a database? For example, in Saudi, you have amber, green, and red employers, right? So is there a database where you can see that there is a specific company which is in a specific zone, green or amber or red?
Okay. So as regards QFC companies, there is no word yet as to whether nationalisation law will apply to QFC licensed entities. Also, the other thing, and hopefully this will become clearer in the regulations, is whether there will be certain roles that will come under the nationalisation law and certain roles that won't. And it may be that white-collar jobs do, or some of those do, and that the blue-collar, so-called blue-collar jobs don't. That's all... there's nothing that we know for certain on that at the moment. As regards the good employer, bad employer, there is, I can't remember the name of the scheme in Saudi, but were you asking about Saudi itself?
No.
In Qatar. Well, I don't know if they're going to do that in Qatar. What they have talked about are financial incentives and other incentives. So it may be that they do something like that. I would expect if they were to do something like that, then there would be a clear process as to what you have to do to get into the certain categories. Now, in Saudi, for example, I think there are about 4 or 5 categories So,
Just an extension of that question.
Yeah.
So you talked about the blue-collar workforce, but in case of even the white-collar workforce,
yes.
for example, in the contracting relationships, especially in the technology function, where these contracting companies, have these high-skilled workers who come in for work visas to be, handed out to other companies in large companies as contract employees, payroll services kind of a businesses. So how would this impact?
If we're talking about employers of record, and if we're talking about sort of manpower supply, already in Qatar, those aren't fully compliant with Qatar law unless it is structured as services contract. As you're probably aware, the key thing is you cannot supply labour or staff. What you can do is provide services, and staff come along with those. Now, what I think we can perhaps predict is if the government sees that people are using these outsourcing services to try and circumvent the need to comply with nationalisation, then there will be a clampdown. Because generally speaking, when we talk about sort of employer of record sort of outsourcing type arrangements, the authorities don't particularly clamp down on those. But as I say, if they in the future they're seen as a way of people trying to avoid complying with the law, then I think that will change.
And do we have a sense of number of what's the available workforce, the Qatari national workforce that is available?
No,
there is no number.
No, we don't.
Thank you. Would somebody else like to?
Just asking for one clarification. You mentioned in the beginning that Qatar Energy and joint venture partners are exempted. Are only joint venture partners of Qatar Energy exempted, or any and all joint venture companies are exempted?
No, just the Qatar Energy joint venture companies. So the best way to look at that exclusion is, are we as a company excluded from the labour law? Because the provisions almost mirror each other. So if you as a company, under that provision in the labour law, the equivalent provision in the labour law, are not excluded from the labour law, then you will not be excluded under the nationalisation law.
Hi, just
Hi.
A question.
Yeah.
Is there any beneficial that can I get if I hire a Qatari man, and what is the benefit of that?
So, as I mentioned, the law refers to financial incentives, but that is one of the things that we're waiting for the regulations to come in as regards. So, at the moment, we don't know what those will be. Once the regulations come out, it should be clearer, but unfortunately not at the moment.
Till now, it's not clear?
No.
Okay. Somebody else?
No? Finished? Okay.
I think I would like to add that Tamimi team will be here post us after our second session, so you will be able to ask your own personal questions and network, and Katrina shared her QR code, so you can directly contact her. And Matthew generously allowed me, he said that for those who are part of the DHL4SMEs program, to get in touch with Tamimi. That's why they're partners of this program, to be able to answer certain initial questions and guide if you don't know. There's a wealth of information on the PowerPoint. All of this PowerPoint will be available on the DHL4SMEs platform for the members. So I understand that everybody tries to take a photo and maybe it's not clear, it's far away, but once after event, if you give us 2-3 days, we will upload the slides and you'll be able to have an access to the PowerPoint, the following PowerPoint, as well as the video of this event. So our next is an interesting topic, tendering, especially for smaller enterprises, right? I would like to invite Diana Abu Al-Adel, specializing in intellectual property, commercial agreements, and cyber law. Diana has nearly 2 decades of regional legal expertise. Her experience in trademark protection, distribution law, and compliance with Qatar's tender regulations is invaluable for businesses seeking legal clarity. Diana, and as well Mr. Hani Al-Nadav, a legal expert in dispute resolution. Hani brings over 25 years of experience in construction, public procurement, and commercial law. His deep knowledge of Qatar's legal landscape and civil code makes him the go-to expert for navigating tendering process and contractual disputes. Please.
Hi. So thank you very much. We'll split the information between Diana and me. I will try to be quick. The purpose here, you will see the information at the beginning especially, they are general related to the tender process, what the law says about the tender quickly, and what the type of contracts the government will enter into with the private sector. Then Diana will be more special about SMEs, what their classification, what the rules special for SMEs under the tender law. So the law related to the tender in Qatar, it's the law number 24 of 2015. Significantly, it was amended very recently. Look, I'm a dispute lawyer, and the advisory about the tender law is, they call it compliance, so you have to comply with the tender law. Why I'm giving the speech today? Because we have been consulted, especially recently with many clients. They want to make sure that they are not doing anything wrong, especially, as you see, the government, they are very keen to have boost the tender process to make sure it's very transparent. It's not subject to any irregularity in the process. So I'm saying that the government is giving huge attention for all the tenders to be very transparent and fair. So these are same as the Qatarization. These entities are exempted from the tender law, so they don't have to follow the tender process. Qatar Armed Forces and the National Cybersecurity Agent only with respect to confidential products. So what does it mean? This is meaning that if the Qatar Armed Forces want to buy, I assume they want to buy arms, they want to buy whatever, they will not follow the tender process. They have their own rules, which is again regulated by laws. But if they want to buy, to build a building, for example, they want to buy catering, they have to follow the tender law. Qatar Energy and same, all the Qatar Energy companies, JV, Qatar Investment Authority, QIA, and the Emiri Diwan. So these are the tendering method. The most famous, I hope you are liking the colors, Diana. Took long time to do it. So the most famous and used is the public tender, and a little bit less the direct agreement. I will explain this. And these four very, very rarely used. So I will not dive into this too much. So the public tender is the tender that we know about it. It will be published announcement. Usually, any government, they will announce this on their website, for example, Ashghal, Work Authority, and on the website, the famous website of the tender, we'll come to it now. So they will announce what the conditions, how they start, and the deadlines, the requirement, financial. Then will be the bidders will put their bids, and this is very, those who are not familiar, the envelopes, there are usually two. And then the consideration of the bids, decision, and you may appeal this. And after the decision is made, we sign the contract. So this is very brief. Now, there is a website. This is a unified website of state procurement. This is where you can find all the information. It's very useful. This is, I recommend that all the interested to visit this website and get the information, whereby the tenders are announced, and you can follow your bid, whether you have been chosen or not. You can put some clarification before you put your tender. And most importantly now, for as far as you are concerned, the classification. This is very important. You cannot apply for any tender or a contract with the government without being classified. And this qualification would differ, depends on the sector, industry, the rating, many factors. It's easy to be done online. So this two-phase tenders, again, I'm not going to, so if this is very complicated, so the government entity is not able to determine the technical aspect of the project. So they have one phase, invite the tenderers to suggest what the work will be entitled. And second phase, after the companies explain what is required, the technical and financial requirement, they will issue the tender, the financial and the technical. So this is, as I said, very specific. The restricted tender, this is, there are a pre-qualified stage to qualify some companies to enter into with direct contract. It's limited to these people. For example, ministry will have, every time we want, I don't know, catering, we'll go to 1, 2, 3, 4 restaurants. These are our only. They have to qualify this. This is a very simple example, but there are many, for example, IP, IT, whatever. So there are many. And again, this is not very much used, but it is in the law. The practice, again, this is in the urgent situation where they're going to the public tender will take long time. This was used a lot during COVID because you didn't have time every time to buy masks, to buy the vaccines, whatever. So this, again, it's not used so often. The competition, this one, it will be used when the required service involved making studies or preparing, for example, if the government wants to do a tunnel and they want a design to put on the wall. So this is, again, this type of artwork, of designs, something special. If they want to, if you remember last 2 years, they changed the symbol of the state of Qatar. It was old and they changed it with this to whatever. So this is this type of work that can involve the competition. And this direct agreement, this is indeed it's used more often by the government. These are the conditions, so it must be urgent, cannot wait, or emergency, and or a company that's the only company available to provide this service. So single source, trial or testing from the source. So this is, all these conditions must be satisfied, yet the approval of this is a bit require high level, so the minister or the head of the government entity should approve it because it's very sensitive. So this again, yeah. This is a direct agreement, same condition, the urgency and the
that the urgency should not be caused by the public entity itself. It has to be actual urgency. And that single source, it could be required to be registered as a commercial agent to prove that this company is a single source based on the circle by the Ministry of Finance, an interpretation of both tender law and commercial agency. So you may be required to be registered as a commercial agent to be considered a single source. Okay, while preparing this presentation, this decision by the Minister of Finance was issued determining the fees to buy the tender documents and to get classified as a company. So this was published in the 19th of this month. And this would show the importance of getting classified, and the classification should be done through the unified website that we referred to. So the tender law provides special treatment for SMEs, the special treatment that you can benefit from if you are considered an SME. But what does it mean to be considered a small and medium-sized enterprise? Resolution number 250 of 2018 actually provides the definition. It has to be a Qatari entity, means established in accordance with the laws of Qatar, not 100% Qatari owned, just the Qatari entity. And there are two rules, the staff headcount and the annual turnover, that would determine if this is an SME or not. So SMEs are three types: micro, small, and medium-sized. Micro, no more than 10 workers. The annual turnover is equal or less to 1 million. Small enterprises, 11 to 15 workers, 1 to 20 million. Medium-sized enterprises, 50 to 250, and 20 to 100. But what if I have, for example, 100 employees, but my annual turnover is less than 20? Then I'll be considered a small enterprise because the annual turnover would be considered more than the staff headcount. So there's an exception for this definition, which is the SMEs that are listed on the Qatar Exchange Venture Market, because those SMEs are governed by their own rules. And also the same resolution, 250, grants the minister the right to amend the definition based on the strategic plan of the state of Qatar. But so far, this is the definition. So what is the special treatment for SMEs? For tenders with a value of less than 1 million, all three types of SMEs are exempted from paying the tender document value. And there is one more special treatment for small enterprises, that they pay half of the classification fees. Micro enterprises, they have two additional, paying half of the classification fees, and also, most importantly, being exempted from the bid bond and the performance bond. Other SMEs can be also exempted from the bid bond and the performance bond, and the advance payment guarantee, which is the guarantee that you provide if you are being granted an advance payment on the contract by the decision of the ministry or the head of the public entity, with the guarantee of the Qatar Development Bank. And also, this is why it's really important that you always visit the unified website. Some tenders could be only permitted to SMEs if the tender value is less than 5 million. Another special treatment is under the reliance on local market. If the contract is signed with a non-Qatari company, 30% of the value of the contract should be performed through local companies. the priority is for SMEs and environmental friendly enterprises. So this is my first slide because I'm an intellectual property lawyer as well. So a lot of SMEs are investing heavily in innovation and technology. And this is where a lot of IP rights come, and this is how you protect your assets. So if you are entering into a tender, you need to be sure whether you are actually assigning the IP or licensing the IP, because your whole project could be built on that IP asset. So if you sell that asset in the first tender, you might be out of business, unless it's worth it. So it's a commercial decision, but you have to be sure what is required under the tender, because you could be giving away the IP asset. In other cases, you could be licensing the IP asset. So it's really important to understand what is required and whether commercially this is acceptable for you or not. Also, registration. Before you bid, and in any situation, if you have IP rights, you need to protect them. And when we speak about protecting them, we need to highlight novelty, because there are two types of IP rights that you lose if you go public with before registering, which are patents and industrial designs, because you would jeopardize novelty. Novelty means new and not known, not disclosed. So you cannot go public with an industrial design, and especially now that very soon we will have a register for industrial designs, you cannot go public with a patent because you will lose protection. It will be part of public domain. So you need to register, and whether you are actually selling me, assigning, or renting, licensing, you should own it. Also, registration will protect you, because when you are assigning or licensing any IP right, you should practically guarantee that you're not violating the rights of others. So having a valid registration would show that you lawfully protected that and that you own it, and anyone who's claiming otherwise would have to prove that. It's also important to understand that mere ideas are not protected. It's the expression of the idea. So if I have an idea of creating an app that would solve traffic problem, for example, that idea is not monopolized. Other people can have that. But if I create an application that's solving that, the way I am solving the problem could be patentable. The code for the software is copyright. The name of the app and the color and the unique logo is a trademark. So if you bid for a tender and you find someone else bidding with the same idea, most likely they're not copying you. But if they're using the same expression, then you could have a valid argument. And that's why you should keep your ideas confidential until you have a proper expression of the idea that you can protect.
Now just we'll go through this practical tips, which all this coming from experience. So problems happened with clients that we want to give you some insight. So first of all, this is, as I mentioned, you have to classify in order to be able to participate. So this is the first step. Go to the website and make the specification. There are some requirements, and you have to fill a form. It should be a straightforward process. So this is the first and most important. And obviously, you have to visit this website from here to make sure that you are not missing any tender. Sometimes it's pop up immediately. This is very important, because sometimes they ask you to send the technical and commercial offer in physical envelopes, which is fine. Although it's it's not recommended to submit it the last day, if possible. But when the application should be submitted online, this is definitely, you should not wait until last day, because we have seen big tenders lost because they start uploading the documents. You know, the tender thousands of documents. They couldn't do it. They called, no one is answering. Everybody is calling, so they lost the tender because they choose to go at the last minute. This is also important. There are some formal requirements, and they are very picky. So the tender bond, the timing, you have to separate the tenders. Don't miss anything. If there is a pricing, you have to put all the prices. Don't say that's okay. I don't need to fill in this one, because they will disqualify you with the smallest mistake. So try to fulfill all the requirements. Transparency. It's very important also. You will have heard of many cases, criminal, referred to the court because of some accusation of malpractice or even corruption in some instances. Sometimes you will never know how important it is. Definitely, it's not allowed to communicate with the official in the government and offer him gift or money. Maybe dinner is a gift. Going to Dubai, it's a gift, you see? So this is all, and it's not allowed. You should not do it. If he's your friend, it's different, but not the person who's responsible for the bid or for the tender. Definitely you should not try this. Fairness and fair competition, this is important, especially if you had worked in the same project previously and there is phase 2. So you have information about the tender, about the project. You have privileged information. You need to be very fair, and you should not prejudice the other bidders for the fact that you have privileged information. So you have to be very competitive and protect your IP rights. This, as Diana said, do you want to add something? Go ahead.
Now, as Mr. Hani said, in relation to fairness, for example, if you submitted a similar bid last year and you offered a certain price, he cannot just, like for this year, double the price without proper justification. That's a red flag, and it would show that you're trying to use your competitive advantage. And also, if you offer something super low compared to, then you're trying to eliminate other competitors. So it has to be fair, it has to be justified, it has to be within the normal. So anything that's totally off would be a red flag. And even, it's not just about not winning the tender, it's about breaching the law of unfair competition, trying to jeopardize the fairness of the tender, which are criminal offenses in some cases, and you could be excluded from any future tender. There are certain punishments in doing that. So it's not just about not winning the tender, it could be even worse. So this is why it has to be justified, properly presented, and within what's acceptable in trade. Thank you.
I think we are done.
Yeah,
any question, we're happy to answer.
So from the tendering process, so there are two corporate registrars here. One is MOCI and one is QFCA. So these tendering laws are applicable to both of those entities registered with any of these registrars? That's one question. The other was that in case that you are disqualified in a tendering process, so is there a mechanism of redressal of grievances? So for example, if I've submitted a technical proposal and they have knocked me out, so is there a process whereby I can file for that I have been unfairly treated?
Yeah, thank you. So for the first question, the tender law applies from one side, the government. So the other party can be any company, even if it's not in Qatar. So if it's licensed in in the United States, in South Africa, or wherever. So because you remember in the World Cup, many companies came, they just applied for non-Qatari companies. So there is no issue. The second question, yes, there is a committee. It's provided for in the tender law, when you can appeal if you feel that you have been treated unfairly. You can appeal to the committee within 5 days, during which the committee, the government, whatever the entity, cannot take decision on the tender until your appeal is ruled over. You see?
Just a clarification on the first question, it was the SME treatment. So the SMEs are treated the same way as if they are...
No, she said at the figures that the first condition for the SMEs to have a privileged treatment, it should be a Qatari company. Now, Qatari, QFC, and definitely, they both are Qataris. Yes.
You mentioned the supplier and service provider classification. On which web page is that?
The unified website. If you go to the unified website for public procurement, you will find exactly how to get classified and what's required. You submit an application, it gets reviewed. And if you're an SME, you could benefit from paying half of the fees for classification, which were determined by the very, very recent decision issued in the
You have the link in the presentation?
No, actually, but it's very easy to find it. The unified website for public prosecution, you'll find the...
okay. It's under the Ministry of Industry or...
Finance.
Finance.
Yes.
Somebody else has a question?
Thank you for the presentation. Thank you a lot. My quick question is, in case that the requirements, the tender requirements, ask the bidders to just explain if there is any subcontractors would be appointed, and later on, the contractor decided, the bidder decided to not go with the subcontractor that they mention it. So do they need to justify why they changed their mind, why they changed the subcontractor that they mentioned, or if there is any implications here? Thank you.
Well, generally you should stick with what you offer, but this would be this would depend on the rules for that specific tender and later on the contract that you signed, if you're allowed, and there are certain, I'm sure this is something that happened before for circumstances beyond your control. But for example, if you bid as a joint venture, can you change the joint venture? Generally no, because you're bidding, because you were granted this tender as those two companies being in joint venture. So it's better to stick to that, to have, and once you bid, to be sure of what you're bidding for, that you have established agreements with the concerned parties, but this would depend on the bid, on the tender itself and the contract.
So it's not all the time compulsory?
Yeah, it's not compulsory. Sometimes, as you may know, the government will not force, but put forward to the contractors, they call it nominated subcontractors. And the contractor must choose one of these. So they don't give one name. They give, like, we have approved 4 or 5 suppliers and subcontractors. You should, for example, if the government wants, I don't want to make publicity, but the elevator wants it Otis, for example. So they have to put it, this is nominated subcontractor. So you have to bring Otis or Mitsubishi, or so they nominate 4 or 5 only. And when you make the bid, if you want to change from one to another within the nominated subcontractor, that's fine. But you cannot go outside these ones. If there is no nominated at all, there will be no issue, because you build your pricing on the price taken from the subcontractor. If you want to change, this is on your peril. You will pay for it.
And also, if you're relying on local company, for example, you cannot later change that local company to a foreign company, like within the 30% of relying on local companies. So it has to be within the same category, and any losses will be on you.
Regarding classification, and you mentioned that you can go on the website and apply so that you can get the classification. So classification is not just based on track record. You can get a classification through the information you provide about your company, right?
The classification would depend on the size of your company and your approved activities. So if you go to the website, you will find full guidance. You could be classified for more than one type of a tender, depending on your approved activities.
So the way I understood it is that the more you do projects with the government, the higher your classification is, something of the sort. Is this a proper understanding?
No,
or?
you have a better profile, but classification it depends on what your services and what your activities.
I see.
So, and as we mentioned, the tender mostly is trying to be fair and transparent and giving a chance to all. So the classification would depend on the activities more.
So if you want to bid for like infrastructure projects, they will require certain classified companies. If you don't meet, for example, A+ or A, this is only offer for these companies. So it should be classified in certain level if you want. Now this is again, there is classification depending on the service that you are providing or the industry. And there is a classification for the small and medium enterprise. So there are many, like the legal service is one, the auditors is two, the contractors, the construction industry, all this type. So there are the different categories.
Thank you, DHL, and Wekton, and Ms. Hani. Mr. Hani and Mrs. Diana for the valuable insights. So my question is about the choosing process, the qualification or the standards. Is it price-oriented, quality-oriented? From your experience, indeed, to know more about the choosing process.
Yeah. So what is written in the law and regulations is that there are, I was talking about the public tender now. They open the envelopes, they take the best 3 or 5 price, provided that this 3, let's say 3, best price, lowest price, but they have to fulfill all the technical conditions. So they have to make sure that they tick all the boxes. Once they tick all the boxes, they took the last 3, and they will send it now to the government. This work is done by the committee, the tender committee. They will send it to the technical person within the government entity. They will choose from these 3. They will look at the technical and financial, and they give a recommendation. Now the committee, based on their technical recommendation, they will make their decision.
So, so what about taking advantage of my competitive advantage, using it, and put more details in the classification area?
I didn't understand. Could you please?
Using competitive advantage of the company or product or whatever, as you can say, take advantage of using it in the bidding process.
Yeah.
Having competitive advantage by itself, if you're offering something better, or if you have a better product, is not a violation. Definitely, this is the whole point. But if you use it unlawfully, if you use that competitive advantage to try to eliminate other competitors unlawfully, this is a violation of the competition law, or it's considered unfair competition under the commercial code. So you should improve, you should be providing better, you should be providing more value for the price. This is acceptable, this is competition, fair competition, healthy competition. But what we're talking about is trying to use that unlawfully to eliminate others.
I think we have time for one more question.
Hi, assalamu alaikum everyone. I'm Hussam, founder and CEO of a Qatari startup called RFXEI. And we are really solving this tendering process challenges from the vendor side when it comes to bidding and responding to an RFP. As well, we are trying to tackle that challenges from the enterprise and the government level when it comes to creation, scoring, and evaluation. First of all, thank you for this insightful and informative informations. It's really, really important till we dedicate ourselves to really build a startup focusing on this. I have two specific questions. One it's regarding the partnership and collaboration within DHL4SMEs, how we can, as startups, SMEs, how we can like collaborate and offer our services within your portal or platform to really have that outreach and help other businesses to solve their challenges, especially when it comes to this like services. Second one, I think it's more technical, maybe to Diana regarding the IP and the intellectual property. Especially for us, let's say startups and SMEs, it's really challenging when it comes to this topic. Maybe if you could highlight or elaborate more on the three topics that you mentioned, the trade license, the IP protection of the concept or the prototype or the idea, plus let's say that code and this kind of stuff, like this 3 level, for us to be more like, we get some insight on that, and maybe in the future dedicate specific session for that with more details for businesses and startups that they born or they have, let's say, an entity here in Qatar, and also they have maybe a representation or a holding in ADGM or in Delaware in the US, where we will be going to register. We register it in Qatar, we register it in the US. This kind of like insight, I think it will be helpful for me as a startup and also for my peers here. Thank you very much.
Okay, I'll leave the first question to DHL. For regarding IP, the first thing that if you are, as an SME, you're building your assets, IP assets, the first advice is never copy someone else. Don't build any business on infringement. It doesn't work. They will sue you and you will lose the business and compensate them. It has to be original. Make it made by you originally. Do your homework. If this was created by someone else before, to be sure that you are not unintentionally copying someone. Once you have your company name, for example, if it's the same as your trademark, register your trademark. If you have a company in Qatar, register in Qatar. If you have a company in the US, register in the US. If you are considering expanding your business in the GCC, register in the GCC. Trademark protection is per country. So the registration in Qatar is not going to protect you in the whole GCC. If you have a copyright does not require registration, but it's recommended. And if you register in one country, you can use that registration certificate as evidence in many other countries. If you have a patent or industrial design, you need to be sure that you file for registration, and you have 6 months as a priority date to expand that protection and file in other countries. How many countries you are registering in depends on, first, your budget, to be honest, and second, your future plans. The more you protect that IP asset, the more valuable it would be, the more protected it would be. If you decide to sell it to someone else, to build on it, in the future it could be one of your main assets. So if you invest as much as you can, but we do it reasonably. When our clients come to us, we do it reasonably because we understand that you don't have a huge budget for IP protection. But as I said, for patents and industrial designs, you lose the right totally. It's within the public domain if you don't register, so you have to register. You should also have proper contracts with your freelance, with your employees, to be sure that you as a company, as an entity, will own the IP rights, that it's work for hire. It's not something that the creator will own, because you're paying for that asset. So generally, these are what you should consider. And especially, please do not build any business on infringement, because unfortunately it comes to me and then we sue and it ends up really bad. So infringement is not a way to start or even expand your business. Thank you.
Thank you. I think the team deserves a round of applause, please. Don, could you please put us the QR code while I'll be answering your first question? Thank you so much for that and for bringing this up. So the idea for this DHL4SMEs is a community. We're there to support the businesses, to support the SMEs, to support anyone who is maybe working in the large organization, thinking of one day having their own company in Qatar, to understand how, what are the questions that they can ask. As you can see here, this is our program partners, and they're experts in their fields. They've all chosen for a reason. So there is, for example, Vodafone. They're experts in communication. There's a DHL, logistics. This is why we are trying to create a 360 degrees program where you will have a chance to come and ask whatever questions you have. So the QR code, nobody is allowed to stand up until you scan and fill it in, please. This is for us to receive a feedback. Thank you, Magda. This is for us to receive a feedback and to work and improve and make our program even better, make it more applicable for you. So because we are doing it for you, we're not, Tamimi is a wonderful company, but they're not. They're here to educate, they're here to give. And they're, let's say, these two topics that we were speaking about today, we thought this might be something that might be of an interest. However, if we know that those are specific questions you have, those are specific areas that you are having a trouble in, it might be a webinar, it might be an article, or it might be worth the whole event like this. So please, this is where we need you, your contribution. The information from this event and from the events before is on the portal. So that's where you receive notifications from us, invitations. If you go back into the resources, there is a PDF on jurisdictions in Qatar, for example, on setting up your businesses. There is a summary of the last events, that we had an event of Microsoft and CBQ. We had an event of Vodafone. So there is a wealth of information, and we're also implementing a cool AI robot into it where you can go and ask a question, and all of the information that was fed by the partners into this program, this beautiful AI lady will be able to answer. This is what we're trying to build. We're building a community of support. As I said, it's the first private initiative in Qatar. I'm sure there will be others who will try to copy us. Nobody will be better, 100%. And I thank you all for, it went longer than we expected, definitely more than 20 minutes. I appreciate you choosing your Sunday evening to spend with us, to learn, to grow, and we look forward to seeing you at our next events. Thank you.